What is a partition lawsuit and when do you need it? So a partition lawsuit is when you have multiple owners of a property and they can't decide how to manage the property. They're not getting along. Maybe one party is stealing money from the rent and keeping it for themselves, or maybe they've ousted one of the co-owners, right? So kind of how does this happen? Maybe one of two ways primarily, right? So people go in and buy a home together jointly, right? Maybe they're boyfriend and girlfriend, maybe they're relatives or friends, and they want to go ahead and start investing into property. So they buy property together. They're both on title, whether tenants in common or as joint tenants. And then over time, something happens. Maybe there's a falling out. Maybe the two individuals break up. And so now you're stuck with a piece of property with that you co-own with someone that you don't get along with, right? So that's when people usually go ahead and call our office and start asking what their rights are. What can they do? What are they allowed to do? The other person allowed to take out a loan on the property? Are they allowed to put tenants in there? Are they allowed to keep all the rents for themselves? What happens when they don't pay the mortgage and you're the only one paying the mortgage or other expenses and repairs? So it's a pretty common issue. I guess you could think of it like a divorce of property is a simple way of thinking of it. So two people that aren't married that need to now kind of go separate ways. So that's the first issue, who can go ahead and file a partition and how does it help? So if you're a co-owner of property, you have an absolute right to file a lawsuit to force a sale of the property and get your proceeds, which you're entitled to based on accounting and based on what percentage of ownership you have on the property. And then, and this is all court ordered, right? The court will go and oversee this. They will issue various orders that we can file and take action on. So that's the first question, right? Is what is a partition and what are your rights that people have when they call our office? The second issue, we have to decide, okay, is this person that's calling us, are they on title? And often, right, you're going to look at the first thing is look at what's recorded on title to decide, is the person that you're meeting with, or is this person actually on title? But some people aren't sure, right? They're not sure if they're on title. They know they've lived there for 20 years. They know they've paid the mortgage, but they actually haven't really looked at title and checked on it. They met with a real estate agent, years ago, and so they believe they are. But other times we have individuals, sign title documents and they didn't know that that's what they were signing. So do they have a partition? No, right? In that case, if they're not on title, we now have to evaluate them for another case, like a quiet title case. Our first job as real estate attorneys is to figure out if they can file a partition or if they need some other type of recourse and legal filing, right, to go ahead and start the process for them. The second step after, figuring out if they have standing and getting all the timeline and background, right, is deciding if negotiating a pre-litigation, so negotiating something early to settle the dispute is an option. Sometimes the parties, the co-owners of the property are in agreement that things aren't working out, they need to sell the property, and they want an attorney to oversee the process, right? So generally speaking, each side is going to go ahead and want to have their own attorney, negotiate the issues of accounting, and oversee that process in selling the property. If that happens, great, right? You don't have to file a lawsuit. We as the attorney will just draft the settlement agreement and then oversee, each step all the way until the property is sold and the proceeds correctly distributed to each side. Now, if there's no early negotiation opportunity, the next step would be filing the lawsuit, right? So one issue that's come up recently, right, is if there's multiple owners on a property, let's say there's 4 co-owners, they each own 25%, and 3 of the co-owners want to go ahead and hire us to represent them in filing the partition. 3 out of the 4 are in agreement to file this partition. In that case, we just have to double check that there isn't any obvious conflicts with those 3 individuals that want to hire us. If they're all in agreement to sell the property, equal ways, there's no accounting, concerns between the three of them, then we could very likely represent those three individuals. They would be the plaintiffs filing the partition action against the fourth person, the defendant. Another question is attorney's fees. So the client's hiring our firm to go ahead and represent them. They have to pay us either upfront or at the end. And they want to know, well, is the other side, the defendant, going to pay for their attorney's fees? Oh, this person is acting unreasonably. They're doing all these things to me, right? Which is forcing me to file this partition. So can I ask the judge to go ahead and have them pay all of our attorney's fees? Generally speaking, no, right? The only instance where we can get some of the attorneys paid for by the defendant is if the defendant either A, does not respond, or B, responds in pro per. We can file a motion for attorney's fees at the end of the case, asking the judge to have the other side pay some portion of our fees. And the reasoning there is because our client had to go and hire us as the attorney to effect the partition. And the partition is really for the benefit of all parties, that it's administrated correctly and goes through the court system. So that's kind of the underlying reason for this motion for attorney's fees. But most of the time, the defendants will hire an attorney, and we will communicate with that attorney and try to negotiate an early settlement. Okay, so yeah, we go back to, we file the complaint, usually file the complaint within about a month, maybe a month and a half if we're trying to do some kind of negotiations beforehand. And then they have to respond. So we file the complaint. There will be a filing fee that we pay to the courts. And the other side has 30 days once they're served with the lawsuit, once they get served with the summons and complaint. They have 30 days to respond to the lawsuit. Otherwise, we can file a request for default and effectively move forward in the legal process without their involvement. Right, so it would make things a lot quicker. And assuming that the other side doesn't hire an attorney and defaults, we would go ahead and ask the court to assign a partition referee, which is basically another attorney. It is not fiduciarily responsible like we are to the client, to the plaintiff, but is acting on behalf of all owners and is a representative of the court. So the partition referee would then hire the real estate agent, list the property for sale, and oversee the sale of the property, right? So if they don't respond, that's what would happen in that scenario. Might take maybe 6 months from the date of filing the lawsuit to try to, get the partition referee and to hire, the real estate agent and have it listed for sale. Depending on the market, right? Depends on how long it will take the real estate agent to sell the property and then have the court sign off on closing the case. If they do hire an attorney, I would say about 95% of cases will settle. And so their attorney will negotiate with us, hopefully early, to avoid unnecessary attorney's fees and costs. But if there's no early resolution, then we move on to the next phase, which is discovery, right? So discovery is us sending questions and written packets of demands of questions that the other side has to respond to. So both sides can exchange discovery. There's also depositions. You can get experts to give you opinions. It's like an appraiser. You can go and get an appraiser to evaluate the fair market value of the property or the fair market rent if there's some kind of rental disputes and offsets there. So as a firm that specializes in real estate litigation, we really take our time focusing on a lot of those offsets and accounting issues, because a lot of times that can be the biggest piece of the entire case, right? Who paid the mortgage? Who paid the down payment? Where's the proof? Sometimes people are paying things in cash, and it can make it complicated to get an exact accounting. Sometimes there's repairs. For example, if you do repairs yourself and you're the owner, you're in most situations not going to get paid for your time and effort. you're just going to get reimbursed for your out-of-pocket expenses, right? So that's pretty much the general kind of middle section of the lawsuit. There's a discovery. We're evaluating the accounting and offsets and reimbursement issues, and then there could be then one party, right, will most likely go ahead and file a motion to ask the court to sell the property and appoint a partition referee. Those are usually granted, and like I said before, the partition referee will go ahead and step in and act on behalf of the court to sell the property and report back to the court. After the partition referee does what they need to do, if there's any other disputes regarding the accounting, those issues might be resolved through a motion for summary judgment. Most of the time, again, the cases are settled and resolved kind of by that point. If not, if your case is maybe one side is being unreasonable, or there's just a significant amount of money in dispute, and so it essentially just makes sense to go to trial, then you would go ahead and prepare for trial. Usually we do these cases as a bench trial, which means there's no jury, right? But you and all the parties do have to appear. You will need any experts, so experts related to the value of the property, any, maybe there's allegations of forgery or something, so we would need some kind of handwriting expert, potentially. The trial includes in about 2 or 3 days. You get a result from the judge on who is entitled to how much of the proceeds from the sale. And then you have post-motion. If there's any kind of disputes about the ruling at trial, or if anybody is not cooperating with the judgment from trial, there could be post-judgment motions or even an appeal. Right now, most appeals aren't successful, but that is, the possibility. So how long does this whole process take? On average, a year, I would say. If the parties are really kind of, not coming to an agreement on anything, then it could last as long as 2 years or more. So, and that correlates with the fees, right? So if there's an early resolution, the fees could be minimal, maybe, $10,000 to $15,000. If the average case, I would say, is somewhere between $20,000 and maybe $30,000. And then if there's a big dispute, especially if the other side responds to the partition saying that there is a quiet title issue or there's some other kind of breaches, breach of contract, breach of fiduciary duty, elder abuse, something like that, right? It can really turn the lawsuit into something else that could be very expensive. Definitely very important to kind of understand the process, understand your rights, and give us a call if you or anyone would like a free consultation.